right, season 4 of Lincoln Lawyer is finally out. Everybody's talking about it, so I'm cheating a little bit. I am skipping the unfinished episodes from 2 and 3, and I'm going straight to season 4. So here we go with season 4, episode 1.
That's the #1 rule of any murder case. No matter what, somebody has to pay.
So this whole introduction monologue here is fascinating, right? Because it sounds like, or at least it will sound to a lot of people, like what he's saying is the state is just going to do everything that they can, and probably people's minds are autofilling, including corruption, to get a conviction. That's not actually what he said at all. And if you listen to it and sort of listen with an open mind and understand that the prosecutor's job is extremely important to justice and to peace in this country, prosecuting people that have actually committed violent offenses is a really important job. And he's saying, yeah, they will spare no expense to do that job. We should all, including a defense attorney like me, say, I'm very grateful for that. And you know what? I am. So that really interesting opening monologue for the beginning of this season. Anxious to see where we're going here.
It's a mistake, one that I intend to rectify quickly.
Yeah, you and every other pendejo in this place.
Hey, you've got the license plate of the car, and they've got you on camera at Union Station dumping the car in the parking lot.
No, see, I was just a pinche driver, okay? I didn't shoot nobody.
It doesn't matter, Edgar. You're the one they caught.
Dadgum. Okay, so spoiler alert. All right, so I actually got the spoiler in the season 3 recap that played right before the episode started, that Mickey had gotten arrested for murder. So, all right, that's what I get for skipping seasons. Obviously, huge spoiler. But, all right, starting this season off with Mickey in jail. Fun little twist here. Excited to see what's going to happen.
What? 2 priors. 3 strikes, and you know what happens.
Man, f*** you.
So autofilling there, he says 3 strikes and you know what happens. If I remember right, and this is California law, it's not Arizona law, and I don't practice out there, but if I remember right, what he means by that is California's a 3-strike state, and on the 3rd strike, it's a life sentence. That'd be 3 felonies, I think. Maybe 3 violent felonies. I don't actually remember, but that's what your brain is supposed to be autofilling there. You know what that means. Not everybody does, because not everybody lives in California.
¿Entiendes ni madre?
Time, asshole! Deuce it up! Let's
go! Okay, so once again, this is kind of fun. I did a video, we haven't actually released it yet, but it's coming. The season of Suits where Mike goes to prison. And so that was kind of fun to be able to talk about some of the law and some of the prison stuff. So, couple things here. Yes, everybody in prison, jail, wherever we're at here is still trying to prove their innocence. Even I worked on a level 4 yard, which was the second highest level it could go. The only higher up level was level 5, and that means they're on 23-hour lockdown. They come out from their cell to go to an outdoor cage to go to rec for an hour a day. Okay, or sometimes it's even actually in the same pod. It's just a bigger cell. Okay, anyway, those level 4 guys, they had been there. Some of them had been there for 10 years, 20 years, and they were still submitting stuff to the court going, oh, wait, I think this is it. I think this is it. I think I could do this. They're still looking for their way out. And you can't blame them. But anyway, pointing out, there's some realism. Some not so realism here was Mickey gets knocked on his butt by this other inmate, and the corrections officer or detention officer, whichever it is, just kind of looks and says, hey, break it up. Time to go to chow. Nope, he'd be over there. He'd probably be deploying chemical agents unless they automatically surrender. Putting them under arrest, separating them, taking them off to separate cells. Maybe they're going to go to a detention unit for a little while if there's an assault. So something really realistic, immediately followed by something not realistic.
I thought you said he was getting a speedy trial.
No, I said that he didn't waive his right to a speedy trial. All that means is they can't delay it. Took 2 weeks to bring charges. After that, they have 60 court days before they have to bring him to trial. There's nothing speedy about this process, honey.
Even when there are no continuances, trial takes a long time to get to. So, you know, they're talking about not waiving your right to a speedy trial, which people do all the time because they say, well, especially if they're not incarcerated, they say, well, I'm not in any hurry to get to trial, especially if they don't think they have a good shot at winning. So sometimes trials, I'm representing some victims, next of kin victims on a case right now. It's been almost 2 years since they lost their loved one, and they're still don't even have a trial date set yet. So yeah, more realistic things here from the Lincoln lawyer.
Until Julian's settlement comes in, we have to save every penny for Mickey's defense.
I thought Julian's settlement was done.
The negotiation is done. It still could take up to a year to drop the paperwork and cut the check. Lawyers.
That's totally real. People hear settlement and they're like, cool, so where's my check? It's like, no, we picked an amount. Right? This check still has to come out, and then bills have to get paid out of the settlement, and so there's always a process. And when it's a big one, like the one that I saw there in the season 3 recap, then yeah, that one could take a very long time. Same thing with a jury verdict. A jury issues a verdict and says, yeah, you won $1 million. Well, you still got to get them to pay it, and they still may try to settle after that and go, hey, look, we don't have $1 million, so we can't give it to you, but you could take $500,000 now. So there can be even post-verdict settlements that delay things. Anyway, more realistic things here.
You sure you didn't get anything from the DA that would help narrow it down?
Are you kidding? It would take an order from the governor's office to get them to hand over discovery.
Yeah, I think I'm gonna need one of those cold brews after all.
I've never actually had a problem getting the state to turn over discovery. Typically, I sign on for a case and I get it in my email. But I see that all the time on lawyer shows, as I think that they want it to be more dramatic than it is. We know that they want it to be more dramatic than it is, so it's fun. But yeah, for me, I tell the state, hey, you sending that over? They send it. I say, hey, I think I might be missing this. They say, oh, I'm sorry about that. They send it.
We brought the motions and your suit. I was thinking red tie because it kind of projects power and confidence.
No, red's too confrontational. Let's go with blue.
That's legit real. What color of the tie, the suit tie, jacket, the combo, the everything. It's all considered to say, okay, and what idea is that projecting? It's a little bit like politicians. If you actually look at politicians and how much they study what they're wearing and when they're wearing it and appropriate for this particular venue and this state, a lot the same, especially for high-level attorneys that are, going in for trial and things like that. I heard in law school that there was a 8-month trial, and that the attorney, that it was either prosecutor or defense, I don't remember, said that he never presented the jury with the same shirt, suit, tie combination. I heard a story about a lady lawyer that said that never wore the same shoes to trial, and same thing, months long. So this, yeah, absolutely, all of that goes into it. And frankly, if I was him, I agree. The red tie, I like this one, kind of a maroon color, right? You could probably get away with that. But if you're doing a bright red, it looks politician. A lot of people wouldn't like it. So wouldn't be doing that if I was him. I agree with him. Do the blue. It's a little more subtle.
All right, the judge you were assigned, Stone, in addition to being a former prosecutor, apparently he's got a reputation for being prickly.
Which
That's
means
bad
we
news.
all need to be on our best behavior. Let's not give him any excuse.
Well, I say that's bad news, but I will tell you, I've had judges that I've looked into that it can go either way. You hear, oh, they came from defense, or oh, they came from family law, or and then you try to predict what that's going to mean for your case, and it just doesn't. A lot of judges, they're fair. So you can have a judge that comes from 20 years prosecutor background, and they go, yeah, but I'm calling it like I see it. I'm calling it according to the law and the facts of this case. It's usually what you get. I've never, I won't say never, but very rarely have I left a courtroom going, that was an unfair outcome, and I think that judge knew it. Only probably once in my mind can I actually remember where I walked away going, wow, that sentence wasn't fair. That judge knows it. I think he just didn't like this guy. So anyway, not usually what you get from judges. So maybe not the most real thing in the world, but hey, maybe in California, who knows?
Mick, don't you want out of jail?
Of course I do, but not at any price. They said bail at $5 million. That's $500,000 to a bail bondsman we don't have, and we're never gonna get back.
Which is why we're arguing to reduce it.
That's legit, okay? Bail, typically speaking, is 10% plus collateral. So 10% in cash plus collateral. So If it is set at $5 million, yeah, $500,000 cash going to a bail bondsman, and then the rest in collateral. Still a pretty tall order for most people, but if you consider that most bail is not set that high, if it's set at $1 million or even $500,000, say it's set at $500,000, they're coming up with $50,000 cash and then $450,000 in collateral. $450,000 is about your average price for a house in Arizona, and so a lot of people will say, well, take my house as collateral. Where they're coming up with $50K cash is still a pretty tall order, but still a whole lot more doable than $5 million. There is another type of bond too that is called a cash-only bond. If they say $5 million cash only, that means they want $5 million in cash, not collateral, to let this guy out. That's a pretty freaking tall order for most people.
Homework and reading is posted online. Shepherdize the cases and tell me if there's still good law or not. Have a good rest of the day, everybody.
So she did repeat herself, by the way. Essentially, shepherdize does mean tell me if they're good law or not. I guess technically speaking, shepherdize means just like look into the case and see if it's had any negative treatment, but that's how you check to see if it's still good law or not. Shepherdize is a term that came, I think, from Lexus back in the day. They had I think it was the guy, Shepard, started giving these updates to the law books, like the ones you see behind me that I never crack open anymore because everything's on the internet. But back in the day, they had to open the book, and so to shepherdize it, they would have this pocket part in the front that would say, like, oh yeah, that case got bad treatment, so you might not want to use that. Now, of course, it's, you know, it's all online. It'll have little flags if you look at it at Westlaw or Lexus to tell you, hey, it got some negative treatment, but not the whole thing, or a red flag to say that whole case is gone. Don't use anything there. But anyway, that's what they're talking about. A whole lot of paralegals do that. I learned that in my paralegal studies degree in undergrad, so yeah, well, that's legit.
The Honorable Lionel Stone presiding.
You notice what's done here? Officer Collins. They're still playing games.
Very good subdued
Counsel
suit.
may be seated. Before we begin, are there any
Good pick, Mickey.
I'm in court.
I'm so sorry, Mr. Richards.
Prosecutor actually answered his phone in court. Okay, at least the judge is freaking out, so that part is legit. I've never seen an attorney, or anybody else for that matter, answer their phone in court. Actually, no, I have seen people sitting in the back waiting to have their loved one's case called or whatever it is, answer their phone, and the judge will just pause everything and tell them, get out, don't talk on your phone in my courtroom. So a prosecutor doing it? No, not gonna happen.
Your Honor, if I could just request 2 minutes, please. My sincere apologies to the court.
No?
Outside, please. Just when you think you've seen it all.
I would guess that the judge would actually say no at that point and say, hang up your phone, we already called the case, we're moving. Anyway.
I'm sorry?
You just said Mr. Holler was set up and framed. By whom, Miss Crane?
Your Honor, I believe that that's irrelevant for the purpose of this hearing.
Irrelevant. Is that so?
Technically is irrelevant because she shouldn't have even brought it up. It wouldn't have anything to do with a motion to suppress, because a motion to suppress is going to be based on whether the officer had probable cause to conduct the search or not, and whether Mickey is set up and framed has absolutely nothing to do with probable cause. If I remember right, just from the recap, there was blood dripping from the car. This is going to be a really difficult motion to win. I mean, even as a defense attorney, I'd be saying blood dripping from the car and you're trying to tell me there's not probable cause to search it? Yeah, I'd probably search the car too. So that's going to be a difficult motion, but it also, the other thing here, she stands up and just says, yeah, we're here on this motion, and begins oral argument. Sometimes you put in a motion, they don't even request oral argument. He may say, yeah, I don't need to hear anything about that. I don't have any additional questions. I have your motion with your memorandum and the state's answer with their memorandum, and I'm going to make a ruling based on that. They don't actually have to have oral arguments. You can request it, but she's just launching right into it, which, also might have irritated a judge.
Is this a motion to suppress evidence or a request for evidence?
It's both. Which is why we filed motions on both.
I'm confused because we're doing one of my pet peeves for courtroom dramas, and I've talked about it 1,000 times, and that's back and forth oral argument. Typically speaking, if you got a motion and the judge says, yeah, I do have some questions on this, you'll stand up, you'll start in with okay, so here's what my motion is about, and you may start your presentation, or the judge might just say, okay, yeah, Mr. West, let's begin your oral arguments. Here are my questions, address them. right? Then you're going to sit down. State's going to start talking, or if it's the state's motion, they'll go first. But in this case, then the state would rebuttal and say, well, you know what Mr. West got wrong here, or why I think this case is different, or whatever. They'll rebuttal. They'll sit down. I'll stand up. I'll get a chance to address the court one more time. This whole back and forth, we love it for drama's sake, but it just doesn't happen. And the whole reason that it does happen that way on TV is that the way that we do it in an actual courtroom setting, usually pretty boring.
Our office had some technical difficulties, emphasis on had. We have rectified the situation and are delivering the footage to the defendant immediately, along with the rest of the discovery they requested.
We're once again delivering discovery to their office instead of sending it out with a link like all discovery comes these days.
I would ask the court to direct Ms. Berg to refer to me as such.
Come on, Mr. Holler, that's just semantics. You are the defendant. You are also the defense counsel. Same difference in this case.
Members of the jury might see the difference, Your Honor.
No response necessary, Ms. Berg. Request is denied. I'd advise you not to press your luck, Mr. Holler.
I would have kept arguing there, not about the defense versus defendant. I would have kept arguing about the discovery, because her coming onto the case and saying, oh, well, I'm brand new, so all the problems aren't my problem. Yes, it is, because you're the state. You're representing the state. And we're not asking, why didn't you get discovery over to the defendant? We're asking, why didn't the state get discovery over to the defendant? The same thing would be if I had associate attorneys that were not getting discovery out or not responding to things. They wouldn't just be saying, hey, why didn't your associate not respond to that? They'd be saying, why didn't Civitas Law Group respond to that? Same goes for the state.
I want to know what prompted Collins to pull me over in the first place. I want to see what he was doing before he decided to follow me.
You want Lauren to file another motion?
If she has to. We need a full hour of body cam footage prior to the start time they gave us.
No, there's a motion that might stand a chance, and that's a motion to suppress based on the fact that the traffic stop shouldn't have occurred in the first place. So in other words, he wouldn't have even seen the blood dripping from the vehicle and had probable cause for the search if he hadn't conducted the traffic stop to begin with. So Mickey's asking the question, why did you even pull me over? So, I mean, if he's saying, yeah, I wasn't speeding, I wasn't, don't have a tail light out, none of that. I will tell you, though, the level for probable cause for a traffic stop just so exceptionally low. If they just say, well, he's weaving a little bit, they're probably going to get it. Really difficult motion to win based on, yeah, you shouldn't have even pulled me over. My driving was perfect. Nobody's driving is perfect.
The front two are on the fritz. Someone got the connection.
They cut. I was home that night. Why didn't I hear the shots?
They probably used a silencer.
A suppressed 9mm round fired inside your home, even if it's in the garage with the door shut, you still hear that. He called it a silencer. That's not true. Nothing is silent about a firearm going off. Even when it has a very good suppressor on it, you're still going to hear that shot.
Yeah, well, I have my own shitty-ass situation.
That's horrible. I'm so sorry.
Anyway, I tried calling, but I couldn't get through, and I was meeting a friend downtown. So
That's a fun reaction because it's legit. Because every time, if you think about it, we solve problems, right? That's what lawyers do. But that means everybody that's calling us has a problem. Well, if you're in her position and you haven't had clients for a while, or your clients are dropping off for whatever reason, when somebody comes into you with a real problem, you're going to be a little bit excited because you're like, hey, that's what I do. So this person coming in, I have a crappy ex and he is making my life just a living hell. She's going to be like, oh, good. Okay, I can help with that. Criminal defense attorneys, you got to try to calm it down a little bit, be a little sensitive, because obviously if somebody calls and is like, yeah, I was arrested, you don't want to be like, fantastic. But I get the feeling, because especially when you're in that situation, going back to when I was just opening the firm, if I actually got somebody on the phone that I knew I could help and wanted to help, it was pretty exciting when they said, yeah, I just got arrested for DUI. You're like, oh, hey, that's me. Cool. Anyway, all right, so that's real. All right, that's the end of season 4, episode 1. I'm totally hooked already. Can't wait to do episode 2, and I'll see you next time.